Everyone, we're excited to have you. Thanks for coming again. It's a new semester, and I hope you all had a wonderful break and that you're not like killing yourself already at the beginning of the semester. So, welcome. And we have just a couple of announcements before I introduce our awesome speakers. We have a general body meeting next Thursday, February 2nd at 5 p.m. It's going to be on Zoom, so we won't be here in this room as usual, but we'll be over Zoom. We're also going to have a happy hour the next day. We'll publish all of that information to you in the next couple of days just through email. After that, on February 9th, Thursday at noon, we have Judge Radler on the 6th Circuit coming to moderate a debate entitled Trump, Biden, and the Future of Presidential Power. So we have some really amazing speakers coming in addition to the ones that we have today. We invite you to those events and especially to our general body meeting, of course. We'll go over the rest of the events that we'll be doing this semester. As far as introductions go, welcome to our speakers. And thank you for coming to discuss freedom of speech on college campuses. This is Keith Whittington. Keith is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University. He's the author of several books, including Speak Freely, Why Universities Must Defend Free Speech, which won the Prose Award for Best Book in Education and the Heterodox Academy Award for Exceptional Scholarship. He has published widely on American constitutional theory, American political and constitutional history, the law and politics of impeachment, judicial politics, the presidency, and free speech. He's currently the chair of the academic committee of the Academic Freedom Alliance and a Hoover Institute visiting fellow. He's been a John M. Olin Foundation Faculty Fellow, American Council of Learned Societies Junior Faculty Fellow, and has been a visiting scholar. I mean, you've just been everywhere. It's amazing. So he's currently working on book projects on the impeachment power, constitutional crises in the United States, and the intellectual history of democracy in the United States. His work for general audience has appeared in the Washington Post, Wall Street Journal, New York Times, The Atlantic, Reason, and Lawfare. He is the host of the Academic Freedom Podcast. John Hasnas, on the other end. John is a professor of law by courtesy at Georgetown University Law Center, a professor of business at Georgetown's McDonough School of Business, and the executive director of Georgetown Institute for the Study of Markets and Ethics. Professor Hasnas has held previous appointments as Associate Professor of Law at George Mason University School of Law, Visiting Associate Professor at Duke University School of Law, and our own at UWCL. He has also been at Temple University School of Law.
That's enough. We'll save time. Just go on.
It's safe to say that he is also amazing. Robert Shibley. Robert, in the middle, comes to us from Allen Harris as one of the nation's most visible advocates for free speech and due process on campus. As executive director and over his 19-year career at FIRE, the Foundation for Individual Rights and Education, now and Expression, he personally aided students and faculty members at hundreds of colleges and universities and traveled to dozens of campuses to speak on these issues. He also played a crucial part in advocating for legislation and policy changes that protects student and faculty rights, including the 2020 federal Title IX regulatory reforms and the first ever state law guaranteeing public college students the right to an advisor in college disciplinary hearings. He's a native of Toledo, Ohio, and a graduate of Duke University and Duke University School of Law, which I believe, John, right? You are as well. Robert is the author of Twisting Title IX, and he's appeared also in the Wall Street Journal, USA Today, the Washington Post, and Time, and several other publications. So please give our guests a round of applause.
Thanks. So I think I'm supposed to lead us off and talk a little bit about threats to free speech on campus these days. I want to try to be very brief and just try to set the table a little bit because I'm conscious of the fact we're trying to get through a whole panel, lots to talk about, and also I want to make sure there's room for y'all's questions before we go. So part of what is distinctive, I think, about our current free speech environment on college campuses is that there are a tremendous number of threats to free speech on campus, and they come from lots of different directions. I think we've had lots of free speech challenges on campuses in the past. This is not a new phenomenon. But what is unusual, I think, about our current circumstances is how many directions the pressures are coming from, both in terms of sort of where they're actually located on and off campus, the kind of people that are advancing them, and the ideological perspectives that they represent. So let me divide the terrain a little bit into sort of off-campus threats and on-campus threats, because I think they're both different in terms of the people and the mechanisms by which they work, but also the political perspectives that they come from. So let me start with the off-campus challenges to free speech on campus these days. I think one is relatively new and the other has been developing, I think, over a long period of time. So let me start with one that's been around a little bit longer, which both of these threats, I think, primarily come from the political right. There is a little left-wing pressure on universities from the outside, but I think the most visible and intense pressure is really coming from the political right being placed on campuses these days. And part of that emerges through an ecosystem that has really developed around universities in conservative circles over the last couple of decades, that is very focused on what's happening in higher education, watching what's happening in higher education, publicizing wacky things that happen in higher education to an outside audience, and then generating lots of controversy around those items. There's interest groups focused on that. There are so-called watchdog groups and advocacy groups focused on that. And increasingly, there's a media environment that's highly supportive of that. One consequence of that is that it's easy to gin up very big controversies out of things that might otherwise have gone largely unnoticed on college campuses. And so things that might seem small and would have been small at one point in time now reach a much bigger audience, become much bigger deals than they otherwise would have been, and become the moment in which then pressure can get generated, directed toward universities. And this often is helped in organizing through social media. And so the rise of the internet, and particularly social media, has really made it much easier to organize around these kinds of controversies and direct pressure toward universities as a consequence. And universities feel that pressure quite intensely. And so when these controversies go viral, they hear not only from alumni and donors, but they also hear from local politicians. They hear from national advocates. They get a lot of heat surrounding these controversies, and lots of college administrators very often will cave in under that kind of pressure in order to try to make the controversy go away as much as possible. A second kind of outside pressure on campus free speech, I think, is more recent, and it's more directly political. That is an effort, in particular in Republican leaning states, by both legislatures and governors and other government officials, to look more carefully at what's happening in higher education, as well as education more generally, and try to apply various governmental tools to restrict things they don't like on college campuses. We've seen some of this developing in the K through 12 space in particular, where I think legally and politically speaking, government has a great deal more authority. They have some authority, obviously, relative to state universities as well, but it's a very contested issue. It's just how much authority they appropriately have relative to state universities. But certainly a lot of the political tools that are being used are fairly ham-handed and have real consequences for free inquiry and critical discourse on college campuses. So one of the notable examples of this, and one of the leading, because it came out of the gate first, but I think a lot of other states are going to follow, is, for example, the Stop Woke Act, which tries to apply some of this divisive concepts, restrictions, or sometimes what's characterized as anti-critical race theory restrictions that had been initially applied in employment training context, the K through 12 context, have now been extended to the university context. I think those are quite troubling in terms of how discourse occurs in a higher education classroom setting. But we've also seen challenges to tenure policies at state universities, greater political intervention in personnel hiring and promotion decisions in general at the state university level. And then this somewhat intriguing new development of DeSantis in Florida appointing a set of trustees to the board trustees for a new college, a large college that is a state university, down in Florida. There had been efforts in the past of sort of using boards of trustees as a pressure point on universities. Part of what's intriguing, I think, about this move is these are particularly sophisticated and strategic actors relative to how universities work compared to your run-of-the-mill member of a board of trustees. And it will be very interesting to see how they proceed. And there are ways in which they can proceed that I think would be within the bounds of political disagreements and perfectly reasonable. There are other ways they could proceed that would be, I think, quite troubling from an academic freedom perspective. So that's sort of a quick picture of sort of outside threats. There's also, unfortunately, lots of inside threats to academic freedom as well. And that often ideologically comes from the left, in part because campuses are overwhelmingly leaning to the left. And the pressures that places is not only on conservative speech, but often a lot of liberal speech, left of center speech that is not sufficiently to the left relative to what people think it should be in various ways. And this gets played out partially through students and students demanding restrictions on what kind of classroom speaking occurs, what kinds of speech other students can engage in, what kind of speech outside speakers can engage in, sometimes even what kind of research professors on campus can reasonably engage in. Once upon a time, students were very much a pro-free speech constituency on college campuses. That's just not true right now. In our present moment, students are often leading the charge in terms of restricting the scope of acceptable speech on campuses in general, and they have lots of tools to do it. And so in some ways, I blame students a little less than I blame university officials. It's up to university officials ultimately to stand up to these kinds of pressures, whether they come from internal or outside sources. But university officials aren't doing a very good job. Which brings to two other constituencies briefly that also on campus are restricting speech. One is the rise of an administrative class on universities. There's extraordinary bureaucracy that has developed in universities over the last several decades. A great deal of that is increasingly concerned with what professors say in various contexts, but also with what students say on college campuses. That bureaucracy is often not very friendly to free inquiry or free speech or academic freedom in general. And they're both initiate challenges to free speech on campus, and they are leveraged in order to restrict free speech on college campuses. And so they are a big problem. And then the third set of problematic actors in universities are unfortunately the faculty and often university leaders. There was a time in which the university faculty could also be counted on as being a pro-academic freedom, at least, if not necessarily pro-free speech constituency on college campuses. That's increasingly not true either. And this is a generational shift that, like the students, who increasingly are coming in with a fairly hostile attitude toward free speech. It's also true at this point that younger faculty are quite hostile to free speech and academic freedom values in general, and are often quite supportive of restricting free inquiry that they don't like substantively on college campuses as well. University leadership is sometimes simply craven and not doing a very good job of defending those principles, but often they're in fact just sincerely bad on those things as well. And so you can hardly count on university presidents, on university officials to watch out for academic freedom. So I think this environment is quite distinctive in that sense of sort of the scope and range of the problem on college campuses. It's extraordinarily depressing at the moment, and it's part of why I'm spending a fair amount of time and energy focusing on these issues these days, because I do think the threat is much more severe than it has been over the course of my career, for example. Thanks.
Matt, I emailed him by our order.
Okay, thanks for inviting me here. I'm happy to speak to you. I had a great time when I talked here several years ago. I'm going to speak for a few minutes about what Keith described as the internal threat. And I live in two worlds. So I teach torts and criminal law at Georgetown Law School. I teach ethics in business school. When I'm at the law school, we're usually considering what are the proper rules or principles to govern human behavior. When I'm at the business school, we're talking about why people and organizations don't abide by those rules. And in my opinion, the problem of free speech on campus is that people like us focus on the first question, not the second. At Georgetown has an excellent freedom of speech policy, speech and expression policy. We've adopted the Chicago Statement. Most of the elite law schools and universities, most of the elite universities have adopted the Chicago Statement. There's nothing wrong with the policy. At Georgetown, we have an excellent policy. This year, FIRE rated 203 schools with regard to how comfortable people are expressing themselves on campus. Georgetown came in at number 200. I'm going to say my experience is that that's a deserved ranking. Right? How can that be? I spent 2 years getting Georgetown to adopt the Chicago Statement. It took me from 2015 to 2017. In 2017, when we adopted that statement, there was a meeting that involved the Faculty Senate, the Office of Student Affairs, University Council, the DEI office at Georgetown, it's IDEAA, the President's office, everyone was on board. Everybody supported this new speech policy, revised speech policy, which was highly protective of freedom of speech. And now several years later, we're number 200 out of 203. That's surprising to many of my colleagues. Like, how can that be? There's one group of us that are not surprised. That's the people who teach ethics in the business school, because we talk about why policies mean nothing. It's how they're enforced, what the enforcement mechanism is that's important. A great policy standing alone doesn't matter. And just to give you a comparison, talking about Georgetown, the policy is great. The theory is the policy. Our policy is to have the broadest possible latitude to speak, write, listen, challenge, learn. Deliberation or debate may not be suppressed because the ideas put forth are thought by some or even most to be offensive, unwise, or immoral. Down below, I have a quote from last May's campus climate newsletter that we get all the time. And it points out, many of you may have been made aware of racially insensitive messages posted anonymously on a new social media flock. We will be continuing to investigate these incidents. If anyone has information about these messages, we urge you to report them. Right? This is typical. You hear somebody say something offensive, we'll investigate, inform on your fellow students, and there will be sanctions. I mean, it's a pretty good example of the difference between theory and practice at Georgetown. We know why, those of us who teach in the business school, because we teach organizational behavior. And this is the kind of result we would expect because of two things: incentives and diffusion of responsibility. Speech and expression policies on campus are designed to restrict the actions or restrain the actions of the administration. So they're designed to restrain the actions of deans, provosts, department chairs, the IDEAA office. That's its purpose. It's to prevent the administrators from infringing on freedom of speech. Who is empowered to enforce the policy? Deans, provosts, the administrators, the DEI office. It's not surprising that they're not enforced well, because these people have no incentive to enforce the policy. The deans, their incentive is keep the organization going. Right? The student protests, get it quiet, keep things going. When the dean at the law school fired a couple of adjuncts a couple of years ago for saying the wrong thing, the president of the university endorsed this as great action. Keeping things going will earn rewards. Standing up for an abstract policy on freedom of expression, if you're an administrator, not only doesn't give you any reward, it probably gets you in trouble. The protests go on. Your school is now tarred as not sympathetic to the oppressed groups. You're just showing more evidence of the racist or paternalistic feature of the school. All the incentives for them are to just get things under control. The other thing is diffusion of responsibility. One thing we teach is you want a certain result, somebody has to be responsible for it. If everyone's responsible, then no one's responsible. So the deans, the other people in the DEI office, their job is to make it so that people are comfortable and there's no bias-related incidents. Their job is to stop people from feeling insulted. Their job is not to make fine-grained distinctions between insult that comes from protected speech and insult that comes from conduct. They're not interested in that. That's not their responsibility. It's also not the responsibility of the administrators. It's no one's responsibility. We got the policy, nobody's in charge of enforcing it. And so it's not surprising that it's not enforced. So a week ago Tuesday, I was invited to the Georgetown Faculty Senate Steering Committee meeting to talk about free speech. They had to get it Zoom, so they had to get on at a certain time. I got on. The previous issue hadn't been resolved yet, and that was talking about some student protest at Georgetown because something was called a bias-related incident and not a hate crime. And the people in the meeting are the provost, dean of the law school, the undergraduate dean, the DEI vice president, and university council. And all of them are talking about the steps they take to mollify the students and satisfy the students and make the students feel as though they're really being listened to. There wasn't any voice in the room talking about whether or not they're suppressing speech. So it's not surprising that you get the results you get. That's why the problem is. So the problem is mostly an organizational behavior problem. I want to suggest that there are a couple of solutions that can be tried. Okay, if the problem is incentives, nobody has an incentive to uphold the speech policy, then what you want to do is try to change incentives. Another thing we teach is change the incentives. One way of changing the incentives is to incorporate this sentence on the board into your speech and expression policy. It says the university will summarily dismiss any allegation that an individual or group has violated a policy of the university if it determines the allegation to be based solely on the individual or group's expression of his, her, or its religious, philosophical, literary, artistic, political, or scientific viewpoints. The reason why that's important is if we put it into the policy, if it becomes part of the faculty handbook, that makes it legally binding on the university. Right now, we have a great policy, and it's not binding in any way. The university agrees to protect the broadest range of free speech. What does that mean? But this means that if someone is subject to sanctions based purely on speech, there's been a policy violation. That means that the individual can file a grievance, and they can also file a lawsuit in the states in which the policies are legally binding. That makes the speech and expression policy self-enforcing. It's not going to change the incentives of the DEI people. It's not going to change the incentives of the provosts and the deans. It will change the incentives of one party at the institution, University Council. University Council is not concerned with winning lawsuits. I'm friendly with ours. They're concerned with not being sued. They don't want to be sued. And if they're faced with lawsuits, if speech is suppressed, they will start to put pressure on the different groups to have more effective training, to not act in the way they're acting now. You can change incentives that way. One solution. The other solution is to assign responsibility, so you're counteracting diffusion of responsibility. My suggestion for that is as follows. I'm the chair of Georgetown's Faculty Grievance Committee. When a faculty member has a grievance that comes to the committee, the first thing that happens is it goes to an initial review panel. And the three of us decide whether or not we have jurisdiction and whether or not the complaint is something that is properly, just as we can properly handle. The answer is no, it's dismissed. The answer is yes, it goes on. And what you need at a university campus is an analog, an institutional review board for speech, so that anyone who is accused of violating a policy because of something that involves speech, it goes to the panel first. And if they determine that the complaint is based purely on the content of the expression, it's dismissed. And it only goes forward if there's what's called conduct, or speech, verbal conduct, which can be actionable. And as long as that board has members who know the difference, the best people would probably be 3 law students who just took Con Law 1. Don't trust the faculty. But people who, you guys, if you had Con Law, you know the difference between conduct and speech, right? The content of the speech is protected, the conduct surrounding it isn't. If you have those three people, then the complaints get dismissed. And so that's my solution. I added a slide after I sent this because I want to say there's reason for hope. I just read this yesterday. Right? In response to threatened legal action, the University of Maine has updated its website to clarify that it has no authority to punish students for exercising their freedom of speech. It further clarifies that students cannot even be investigated or questioned for a bias incident when the incident involves protected speech. That's incredibly important. You might have heard of what happened to Ilya Shapiro at Georgetown. He wasn't sanctioned. He just had a 4-month investigation over a tweet, and then they were going to let him come back. In these situations, the investigation is the punishment, because when he was subject to investigation, the next day, the headline of the main campus newspaper, The Hoyer, had a photograph of him with a headline that said, "Law school investigates racist administrator," which is really damaging. So this kind of thing can make a difference, and the reason for hope is one school just changed. If you're interested in any of this, there's an extremely long version of it, which I published here, so you can get this and have it in a fully fleshed out form. Thanks.
Thank you. So before we get to Robert really quick, we're going to just switch over the PowerPoints. If you guys have any questions for either John or Keith, let's just address them right now. Okay.
So, like, I know there's kind of like a separation between, like, you know, state schools that are like more like North Carolina, for example, versus like a private institution. How does the differences of that affect, like, how, like, you know, policies and stuff like that will like affect free speech?
It could have a big effect. The state schools are bound by the First Amendment. So they're bound by the First Amendment. The difference between content and conduct is imposed upon them. They have to abide by the things that you learn in Common Law 1. Georgetown's a private school. We're not bound by that. We can make any rules we want. We could have no free speech. What happens, though, is we adopted the University of Chicago statement, which was created to parallel the First Amendment. So our school imposed the First Amendment restrictions on ourselves. And since we made that a public representation, we now have to abide by it. So we're covered as well. But private schools that don't have the same level of protection, that they're allowed to not have the same level of protection.
I'll get into that a little bit, actually. Again, thanks for having me. I have some slides here, and I'll try to go through it, give you some of the legal background for why we have, legally speaking, the free speech on campus sort of framework that we have, and give you a little bit of context. And first one I want to highlight, there's 3 cases I want to highlight here out of history, is Sweezy versus New Hampshire. And this took place in the context of the era of McCarthyism and the panic over the Soviets actually getting the atomic bomb from communist spies here in the United States. And I think it's hard for us who didn't live through that to really comprehend the panic that people felt about it. There was real feeling in the United States that communist infiltrators were going to get us all destroyed by Soviet nuclear weapons. And it was in that context that the New Hampshire legislature passed a law saying that subversive persons would not be eligible for employment by the state. And they gave the Attorney General the authority to investigate those. And one of the people he investigated was this professor who was a Marxist, Paul Sweezy, at the University of New Hampshire. And they questioned him, and he denied being a member of the Communist Party. He was a member of the Progressive Party. And he also denied advocating the violent overthrow of the government, but he would not testify either way about the content of a lecture he had given at the speech. So the Attorney General went to the state court to get a contempt citation and try to jail him. And this went to the Supreme Court. The which issued this, one of its earlier, really very stunning and broad sweeping exhortations to us to care about free speech and academic freedom on college campuses. The essentiality of freedom in the community of American universities, they said, is almost self-evident. No one should underestimate the vital role in a democracy that is played by those who guide and train our youth. To impose any straitjacket upon the intellectual leaders in our colleges and universities would imperil the future of our nation. So this is pretty broad, sweeping stuff. Went from the A-bomb panic to the panic over hippies and the 60s and Vietnam and bombings. And that led to a couple of the other two cases I want to highlight that are more historical. First is Healy versus James. And this was where Central Connecticut State College, its president more or less unilaterally denied official status to a left-wing group called Students for Democratic Society because they had been associated with violence on other campuses. And I have a picture there of the situation on Columbia University's campus in New York. This is the 1968 Columbia uprising. 132 students, 4 faculty members, and 12 police officers were injured when the NYPD came in to clear this out. And to give some more context about the year this is happening, there were dozens of bombings on campuses during the late 1960s, including 3 in Michigan, at the University of Michigan within 1 year. The first one was 4 to 6 sticks of dynamite and blew a crater in the sidewalk. And to be clear, to give you some perspective, what do you think would happen if somebody bombed American University 3 times this year? I mean, I feel like you'd probably be out of class, but that's not what happened in the 60s. People just kept going to class, the university stayed in session, etc. I mean, to give you so I just want to give you sort of a perspective of how freaked out, and justifiably so, leadership was about a group like Students for Democratic Society coming to their campus. And yet, once again, that the court didn't allow that. Saying that there was no room for the view because of the acknowledged need for order, that First Amendment protection should apply with less force on college campuses than in the community at large. That actually said it might actually be more important. And this was the first really straightforward explanation of that, particularly because it was during this time that colleges were going from this in loco parentis idea where students were still really kids and the college kind of had to be their parent, and you had to, dorm moms, you had to sign in, or my mom had to sign in to her dorm every year at the same college my dad went to, Tennessee, where men didn't have to. I mean, it was that kind of, literal paternalistic stuff going on. And so here the Supreme Court said, no, that's not what needs to be happening on public college campuses. And then finally, from a similar time, this is Papish versus Board of Curators, Missouri. This was Barbara Papish. She was a grad student, I think a journalism student, and was distributing and helping. I think she may have been the editor of this underground newspaper, the Free Press. That's their masthead. And at the time, this is University of Missouri, they had a restriction on, they said that students were required to observe generally accepted standards of conduct, and they also prohibited indecent conduct or speech. Well, there's a naked woman right there on the front, and it didn't get better when you looked at the rest of the issue of this newspaper, which on the front page had a cartoon with policemen graphically raping the Statue of Liberty and Goddess of Justice, and a headline that said "Motherfucker Acquitted," which was referring to a 60s radical group, which was literally called Up Against the Wall Motherfucker. That was the name of the group. They had lots of very creative names back then. And again, the Supreme Court, despite, we're talking, a bunch of, older gentlemen at this time said, no, we're not going to allow universities to restrict this. The mere dissemination of ideas, no matter how offensive to good taste, on a state university campus can't be shut off in the name alone of conventions of decency. So this has led to sort of this consistent failure of, when challenged, and at state universities and colleges, speech codes falling when they are challenged in court. And that's based on the two kind of challenges that usually happen in First Amendment cases. Not always, but usually speech cases, I should be more specific. Vagueness, when you can't really tell what's prohibited by the restriction. So that'd be, if you say indecent speech is restricted, that's got a couple problems, but one of them is nobody can really agree on what indecent is. It might change from time to time and place to place, and from person to person. And the other one is overbreadth. The policy covers too much speech that's obviously protected by the Constitution. And that came up in the very first sort of modern era campus speech code case, Doe versus University of Michigan, which is a district court case, but it's kind of the granddaddy of these from 1989. And this, again, serious things were happening here, not bombing level serious at Michigan, but what had happened led up to this effort by the University of Michigan to ban racist speech, is what their goal was. Somebody had posted flyers around campus using racial epithets against Black people and declaring open season on Black people. Racist jokes were broadcast on the campus radio station, and then when these led to protests, some person hung a KKK robe from their dorm room window. So you can understand that people would be upset about this, but as it turned out, and as these restrictions usually turn out, didn't really get applied the way they were expecting. One of in the court case, they discussed some of this, but one of them was, one of the early ones was a Black social work student had said that he believed homosexuality was a disease, and he was going to develop a counseling plan for changing gay clients to straight. That was one of the early sort of internal prosecutions over this. Somebody went after a student for telling a limerick, making fun of an athlete for being gay, or supposedly being gay, and it's sort of a cultural artifact. He had to agree to go to a gay rap session. I guess like, we're going to rap about this kind of session, not performing rap. And then another Black student was made to write a humiliating apology letter for referring to a student as white trash. And so this wasn't really working out the way Michigan had planned. And in any case, the court shot it down, pointing out the Supreme Court was not likely to look favorably on this. Now I just want to highlight a couple I was actually involved in during my time at FIRE. College Republicans at SFSU versus Reed. This is students decided they started to have an anti-terrorism rally. It was like 6 or 7 of them, where they were stomping on Hamas and Hezbollah flags that they had printed out from the internet. And actually, when Muslim students came up and were upset about it, and I know this because I was involved in the case, the reason they said they were upset was because the Hezbollah flag has the word Allah written in it in Arabic script. That's part of what's on the flag. And that was considered to be desecrating the name of Allah, which is actually what the students got charged with. But the students who came up to the protesters were actually satisfied, because the protesters said, we didn't realize that. Can we just mark it out and go on with this? And the students said, yeah, actually that's fine, because it's no longer the name of Allah, because it's been taken out of there. So they went on with it, but the university wasn't done with it. And so they went after them. And again, this civility code was struck down, and also this requirement that they act in accordance with the goals, principles, and policies of the college. The John versus Temple, near my then hometown, of Philadelphia. This is a guy who came back. He was a grad student. He was a tank driver in the Gulf War, and didn't believe that women should be in frontline combat roles. This caused him a lot of trouble in his graduate program. Ended up going to the Third Circuit, and they shot down Temple's speech code. Temple is public. It's kind of a strange thing, because a lot of people think it's private. But the Court of Appeals shot it down for saying that it provided no shelter for poor protected speech. And you can see the language here actually starts to sound a lot like the language of the speech codes and speech restrictions that we see. This idea of unreasonably interfering with somebody's educational appearance, performance, or has the purpose or effect of creating an intimidating, hostile, or offensive environment. So even if you didn't mean to do it, can still be guilty. And then this is a very recent one, Speech First versus Cartwright. This is kind of a new generation of speech code cases where organizations like Speech First have started to bring suits against colleges before they're actually enforced, saying that they've been, bringing these facial challenges, saying the law is invalid on its face, which, it can be more difficult when it comes to standing. Courts don't really like to take these sort of speculative things, but in the First Amendment context, often they will. And here, this did go to the 11th Circuit, which, produced a really good opinion, saying that, whatever the merits are here, this is still about core political speech, and it is overbroad. You can see it covers substantially more speech than the First Amendment permits. It's fatally overbroad. Quick note, because somebody had said it, speech at private colleges, private universities do have a First Amendment right to determine their own rules. Like John said, Georgetown could just decide they don't like free speech, and they could say we're not going to have it, with some restrictions. School accreditors, most of them require some kinds of academic freedom guarantees, and while there's some exceptions for religious organizations like that, it'd actually be harder to just completely disavow free speech altogether. But I looked up American University, and AU was actually the 4th school on FIRE's list to adopt the Chicago Statement, has this, statement saying, I don't think this is from their version of the Chicago Statement, but from their policy saying that they protect freedom of expression and dissent for all members of the university community. And actually, this is a very good statement. It says the only limits on free expression are those dictated by law. Limits necessary to protect the safety and rights of others. Okay, you got a little wiggle room there. And limits to ensure the normal functioning of the university. So there's some wiggle room there, but actually a fairly strong one. And I'm not going to subject you to all of these, but there is, as John also alluded to, for the most part and in most states, university and college contracts, even if they're a private university, universities and colleges are considered to have a contractual relationship with the students that includes their promises of free speech, following their own rules, et cetera. And so you do have a contract claim if you can prove that they have violated those. But that's not always true. I'm ashamed to say that our mutual alma mater, Duke University, is in North Carolina, is one of the ones that doesn't. Apparently, they didn't actually have to give me anything for my $250,000. They went all the way to the 4th Circuit and got the 4th Circuit to buy into the idea that their bulletin is not a binding contract. But overall, I think colleges do have something to worry about when it comes to contractual agreements they make. And then finally, I just like John talked about, if you're not familiar with the Chicago Statement, this was put together by the Committee on Freedom of Expression at the University of Chicago, and it's been pretty influential in terms of getting colleges and universities to adopt it. Usually with a lot of effort from somebody there who cares about it. But it is popular in that sense, and I think it's something that does give a really important, sort of lodestar to be attracted to. But at the same time, it's not really a self-actuating policy, and it's not intended to be. It's sort of a statement of principle. It's not something that you usually can't charge somebody near you with violating the Chicago Statement, but it could be part of the case that you want to make. And I think it's nevertheless, an important effort. So if you have any questions, please feel free to email me, and thanks for having us.
Thank you.
Even if contract doesn't work, you can, like these torts, you can try misrepresentation.
Oh, sure.
So there's still a way to go on after.
Thank you. We'll go to questions now. So whoever has questions. Yeah.
So I know that in your book you talked a little bit about trigger warnings and safe spaces, and that kind of goes hand in hand with what we're now seeing as cancel culture. And so I'm curious how you all think that you can combat an issue that's not as, for lack of a better word, tangible. It's not like DeSantis passing the Woke Act and it's an express limitation on free speech. How do we combat something that's more of a fear of free speech?
I think it's a challenge, right? Because some of the issues that arise on campuses are not about policies. The policies in place are actually pretty good often. It's questions about enforcement and also even harder question, which is one of culture. And so to the extent that what we're seeing in part is a lot of peer pressure among students in particular, but also actually among faculty, that really is inimical to free speech culture on campus. Policies don't address that very effectively, and it's hard to change a culture. And so I think it requires one, actually having to have fairly explicit conversations about free speech and why it's important on college campuses and what its requirements actually are. Trying to work through some of those disagreements, try to educate and socialize people into accepting those values as being important values. And then it requires a lot of sort of very low level on the ground battles to try to get people to live up to those principles to a great degree. But I do think that's one of the really hard challenges we're facing. It is not just a matter about policies and statutes and laws or even official decisions. It's a lot about culture and peer-to-peer pressure, which is hard to fix.
I'd like to say something about the question too. My presentation was about getting the administration to act properly. That's important. That's actually not the biggest problem on campus. The article I referred to talks about two fears. One is fear of administrative sanction. The other is fear of the reaction of your fellow students, what you call cancellation. And that's probably the more oppressive of the two. That's more significant. My answer to that is, to the most extent, get used to it. Right? If you hold a minority position, that's the way it's going to be. People can disagree with you. People can not be your friends. Yeah, I don't use social media. They can not let you. All of that kind of social pressure goes with the territory if you hold a minority position, up to a point. There is some level of protection that you should have. Again, it's nice to speak at a law school because most of you have had torts, which is what I teach. There's a line you can't cross, and at that point, tort actions make sense. So the kind of things that happened to Charles Murray, where people are thrown down, people are spit on, people are impacted. Others go out of their, will be familiar to you, others go out of their way to make your life miserable. If you just studied the tort of the intentional infliction of emotional distress, you know that there can be actions there. So when the response crosses the line into behavior designed to harm people, either physically, emotionally, or materially in a way that can be protected, that's when tort action would help. It's impossible now because it's too expensive. Nobody will bring a lawsuit. But FIRE is solving the problem for us. FIRE is creating a pro bono network of lawyers who will take cases of this kind of abridgment of speech rights at no cost. And you don't need, you just need a small wins of $5,000. Once that gets around, behavior changes. So there is a way of trying to fight cancel culture if it goes too far, but basically just get used to it. There's nothing you can do. That's the way it's going to be. That's the way it's always been for people in minority positions. That's the way it was for the communists and the people supporting communism in the 1950s.
One
Thank
thing,
you.
I'll weigh in too quickly. One thing that I was surprised by when FIRE started doing our, and I'm still a senior fellow at FIRE, so I feel like I can still say our, started doing our ratings of the campus climate, was that the strongest correlation, correlation between a single factor and the overall ranking of the school was the students' perception of what the leaders thought about free speech. And actually, I was really surprised by that because I don't remember caring about what my college president or leadership or whatever said. It was kind of like a sighting when we saw the college president at Duke or a dean or something like that. Now they seem to be everywhere. There are probably 2 or 3 in this room, right? But I was surprised by that. But actually having the college leadership come out and say, no, we don't punish this. I'm not going to do it. here's why, and then sticking to it would actually work 99% of the times for college administrators. But, they have a number of reasons they don't do that, most of which are bad. But that actually has a weirdly big influence from what I can tell. And also just, you may notice this, I sort of started to wonder back before Elon Musk bought Twitter, and Twitter was banning people or would remove your blue check, not because you weren't that person, but because it didn't like what you have to say or whatever weird apparatus it was. One thing I noticed, and I noticed this mostly starting about Milo Yiannopoulos, if you're aware of that guy, was that almost every story about him would start out with how he'd been deplatformed by Twitter. People, unfortunately, are followers. And when somebody who is perceived to be influential starts saying something, people will follow it. So I think there actually may be a smaller group of people to target with the idea that, all right, you need to stop allowing cancellation to happen. Whether it's the big companies, the social media people are the obvious ones, or universities should be the easiest one. Just have them say, I understand you're upset, you're entitled to be upset, but nothing is going to happen. And that's the end of this. And don't ask me again because I will give you the same answer. That actually, I think you could probably turn it around a lot faster than you think, but those people are powerful, they are wealthy, and they have very little accountability. And so getting them to do that is a tough one.
I was curious more about the public institutions, especially after Garcetti and the current circuit split, about whether its analysis should apply to public university professors. And I was wondering, sort of two-part question, do you think SCOTUS will address this anytime soon? And how would you describe the current state of protections, constitutional protections for university professors that is now?
I think SCOTUS is likely to address it soon, right? We're getting lots of legislative movement on this issue that's really exploiting the Garcetti exception. Florida's legal posture in their litigation over the Stop Woke Act precisely leans on Garcetti in a particularly strong way. And so I think eventually we're going to get the Supreme Court weighing in. I don't know if Florida will continue trying to push this, for example, all the way up. And it's not entirely obvious to me how the court's going to rule on this. I think in general, the current Supreme Court did pretty good on free speech issues, broadly. But how Garcetti ought to apply to university professors and state colleges is, I think, a genuinely complicated issue, which does not have really easy answers to it. I've tried lately in my own work to try to sort of show a path toward providing those protections. But it's not an easy call, and it's not entirely obvious to me how the Supreme Court will actually rule on it. So I'm cautiously optimistic, both that they'll hear it and they'll rule in a positive way on that. But we'll see.
I'll disagree a little and say Garcetti was a mistake. It should be with. I don't think it's necessary. I do think that if it got to the Supreme Court on a case that did not have an extremely unlikable plaintiff, I think they probably would make it clear that the Garcetti exception does apply. Because right now it's a footnote saying we're not going to decide this, and there is that circuit split. Although thankfully most of them come out on the idea. But the problem is you can't operate a university. Fundamentally, a college professor is not the same nature of employee as the DMV, and you can't make them. The job of a college professor is sometimes to disagree with the government's preferred message, and they literally can't function if they have to operate under that. And the only reason they're functioning now in states where they don't have Garcetti is because the universities are basically allowing them to, out of realizing that they can't operate the university if they actually do that, which is not a sustainable position.
So a little bit of background on the question that I'm about to ask. So I was actually talking to a DeSantis supporter the other day about the Stop Woke Act, and he told me why he supported the act. I don't know to what extent his views represent that of DeSantis's or just the logic behind this act, but it is an interesting argument. So he said there is overwhelming evidence that the enemies of free speech instinctively understand that free speech is simply a means to achieve, to capture and consolidate power. And that's why they used to support free speech, because their movement in its infancy would not have survived if it weren't for protections of free speech. But now, once they're in charge, once their power has been consolidated, they censor free speech because they instinctively know that that's how they achieve power. That's how other people who are going to overthrow them will achieve power, through free speech. And therefore, he said, because conservatives are being battered, they have to be as bad as their enemies. They have to play their own, play the other side's game. And now with DeSantis, conservatives finally have a chance to fight. They are in power right now, at least in Florida. So what do you say to this guy? Well, why is he wrong? What would you say to him as defenders of free speech?
In terms of bare knuckle politics, I'm not sure he is wrong. There is being uncompromising and using every tactic that you can to your advantage is a really good way to make political change. There's a reason the IRA kept it up for so long, and they were using killings and bombings, right? So from a realpolitik standpoint, maybe he's right, but I hope he's not right. And, I would hope that we could rely on the institutions that we already have to, be self-correcting. But, I do understand that, people are impatient about that. And, one of the co-founders of FIRE thought the same thing, that it would be called the Great Generational Swindle, that the 60s radicals who took over the academy were closing the door on people who disagreed with them in a way that the people that allowed them in didn't do. But I think that's also human nature. I think that was probably inevitable. So what's the right way to go about that? Only time will tell.
The kernel of truth in the argument you described is that freedom of speech is a threat to power.
Exactly.
And that's why we support it for everyone. It's a threat to power. If you're in power, you don't like freedom of speech. But if you understand its purpose, then we spend our life trying to support it.
Yeah, ultimately, free speech is an oppositional value, and certainly people are hypocritical about it. So once they get power, you often see them suddenly flipping a switch on that. It's hard to get people to retain a commitment to those principal distinctions when they themselves exercise power and they see themselves on the other side of the equation. Partially, you want to try to design institutions that can hold people's feet to the fire. It's one virtue of independent courts. And you hope then courts do a relatively good job in ways that politicians often will not in terms of protecting free speech. You hope that would be sort of true in universities. Part of what's very disturbing about universities at this level is that they were the kind of institutions with kinds of practices and culture that was more willing to defend it. Now they're much less true. And ultimately, though, I think you also have to, one, you try to design institutions. Two, I think you do sort of try to establish a kind of political bargain, right? That both sides need to see that they're going to be worse off in the long run if no one is committed to free speech, because the other side is going to beat them over the head. And so you try to get a sort of mutual disarmament on the free speech stuff by saying, look, we both know we're going to be in the minority position at some point. Wouldn't we all be better off if we took this particular weapon off the table in our normal political disagreements? That can be a highly successful strategy in general, but it depends some on the political situation, the political climate, right, as to whether or not people are actually committed to that. And then third, I think you do still have to try to fight the cultural battle and sort of persuade people these are actually important values in the long run. We'll be better off in the long run, even if you got to tolerate some speech you really don't like. In the long run, you're going to be better off as a society to do that. Because I think if you lose that battle at the end of the day, if the culture really turns hostile to this, you're going to be screwed, no matter what the kind of considerations are.
Did you have one more question? I know that you had one.
I did have one, but it might be a long-winded answer out of you guys. So I was just kind
It's
of.
given, right?
Yeah, exactly.
Let's go. So just kind of looking at like university policies, and I went to a small private liberal arts school. where academic censorship was definitely something that occurred, and it was recognized by quite a few professors. But it was hard for like the professors that were recognizing it to say anything because like they were non-tenured profs. And so it's like those sorts of things. And do you think that like putting a policy in place within like professor handbooks and stuff to say that they have to basically like they could be put, whether they're tenured or not, could be put under sanctions if they're suppressing speech within their classrooms? Because like an example is I had to write an essay for one of my classes where I was going with like an idea, and my professor told me straight up, like, if you write about that, like you will not get an A. Like that is not an arguable point. So instead I wrote like a pro-communism paper to make her happy. And like I did fine, but I'm like, I did not believe anything I was arguing. And it's like, and I wasn't able to like put the dialogue out there the way I wanted to. Do you think that that's like a policy like that could be usable in like private institutions since they don't have necessarily the same free speech protections?
I will respond, but it's not going to be an optimistic response. I mean, you described an uncomfortable experience for you. Right, so when my colleague was talking, I was in college in the 60s. I remember all of that. Things were uncomfortable then as well. It's actually a feature of every generation that we get professors who, instead of being neutral parties who are concerned with our education, they're pushing a particular agenda. That's not new. So it always happens. There are certain protections associated with academic freedom, which Keith can talk about better than I can. What can be done is to empower people to protect their own interests. So if someone who's untenured doesn't, of course we don't want to talk because there's intimidation, but if someone who's untenured does do something that causes an improper response, they usually have no hope, right? What you want is something that, like my suggestion of the initial review board, before any action can be taken against anyone, someone says, is this based on protected speech? And if the answer is yes, then it's dropped. That's probably the most you can get. But I have nothing that will solve the problem you describe. It's perennial. Human beings are like that.
I think it's a very hard problem to solve. I think one can make some progress on it. I'm very skeptical about policy solutions as such, because it's not at all difficult to imagine how that gets abused in its own ways that are even more troubling, or at least as troubling as this. I actually don't think it's necessarily a private versus public college distinction there. Actually, I think there's First Amendment wiggle room to get you something like that to deal with. So I don't think it's a First Amendment problem, but I just think as a policy design, you likely probably will not like the results that emerge out of that. But frankly, I think although smaller bar colleges, like you described, are actually a real problem in this regard because it's a relatively small number of faculty. Because I want to say one of the kinds of solutions to this kind of problem is transparency, right? If other students know that's the way that professor operates and what the classroom is, it's easier to avoid that person. Problem with small schools is there's limited selection, and so you can't easily avoid those people. That's one reason why I like bigger schools. I think professionally, though, that's also true that we are not doing a good job to socialize young and prospective academics into understanding the nature of their job properly. and so there is a human nature thing that you just can't weed out very easily. But we should be doing better in our own training and socialization as scholars to get people to understand that's actually not your job description. And part of what's disturbing is there is a substantial fraction of professors who think that is their job description, is to do exactly what you encountered. Again, that's not a perfect solution by a long shot, but I think we're not doing a good enough job to try to actually grapple seriously with that kind of problem.
Thank you.
That's why faculty hiring is the problem.
Faculty hiring is critical, although even hiring is tough because it's one of these things that's not very transparent. It's hard to know who's going to behave that way. People change as well, right? They behave that way differently over time. You see that kind of thing emerging. It can be really tricky, I think, to you think about sort of how do you solve principal agent problems in general, right? And part of it's about sort of designing the right monitoring mechanisms. Partially it's about selection of the agents in the first place. But they're hard to do. And in this context of teaching, it's particularly hard to do. A lot of teaching is not very transparent to the outside, right? And it's not closely monitored. Hard to know what's going on. Sometimes hard to tell the difference actually between what you're describing and other kinds of things. And so, you hear lots of stories from students about, I was being indoctrinated, they wouldn't let me say the right thing, whatever, right? And then as you start trying to dig down in the story, it's like suddenly becomes more apparent from a faculty perspective. You sort of realize, oh, I see what you're doing. I see, but there's another way the story could be told, right? That looks rather different. And so there's clearly this really bad behavior that I think genuinely occurs pretty often. But there's other things that students think of as bad behavior that's probably not. And it's really hard to tell that difference sometimes. It's hard from the student's perspective. It's certainly hard from outside administrators and other kind of perspectives as well. So it's just a really, really challenging problem to solve.
But that kind of attitude, even, though
Yeah.
Keith is right, the kind of attitude and having, it is not uncommon at all for students to come away with stories like that.
Yeah.
I don't know what the support for higher education is going to continue to be when we have this huge cadre of people who all feel like they got screwed, for, to the tune of many tens or hundreds of thousands of dollars. And we're allowed to say that. I used to be amazed how many people in journalism, for instance, would have a story about getting censored during undergrad, being on the newspaper. That's actually how I ended up at FIRE, and like how frequently this was happening. And now it's happening more and more. I worry about what it means to have millions and millions of people all saying, you know what, I'm not I totally got screwed, and they aren't really up to education. And that's how you get this idea that, well, maybe there's nothing left to save, and let's go full scorched earth DeSantis on the whole situation.
Yeah, universities really need to clean up their own house.
Yeah,
On
they
this.
have a real interest in it.
They have a real interest in it, and because it's the kind of DeSantis top-down solutions, I think, are not very attractive. But I totally understand where they're coming from. And if universities don't do a better job of improving from within, you're just inviting it.
But you have my sympathy because I went to a small liberal arts college as well. But now that I'm on the other side, an even bigger problem is students look up they read our stuff and they find out what our position is, and then they write articles, they write things that they think will appeal to us on that ground. And by the way, that kind of writing is always inferior to saying what you actually believe. But they do it.
Thank you.
Thank you. Thank you to our distinguished guests. We're going to round of applause. Be sure to sign out on your way out, and then we'll see you next Thursday at 5.
If anyone still has a little hunger in their belly, there's some butter, so.
Georgetown is number 200. But nobody at Georgetown is there. There's no bad actors. They're not ideological. When people speak on this.